Courtroom Procedures 101, frequently asked questions and answers. And just some general things concerning criminal court for new reporters and other reporters as well. Some information, and hopefully there'll be something on here that will help you out. If you have any questions later, just feel free to call me anytime. In criminal court, the court proceedings itself, just basically when you get ready to go out to court, you'll have your judge's name, the county that you're going to, and you will know, of course, the court reporter that you're filling in for. A lot of times you'll have their information, and feel free to ask that anytime. I always share that information with each other in case anything comes up, they have any questions, because no one knows the court reporter better than the ones who works in there usually, or who works in there quite a bit. So, but you have all that information, know where to go, the courtroom and all of that. So the next thing is deciding when to be there. So you would need to be there at least 30 minutes before. I'd say most people get there about 30 minutes before, some maybe even more before then, but that's plenty of time. But in case there's traffic, you know. But if you see that you're not going to be able to get inside of the courtroom by 15 minutes before the court starts, then you'll need to either call the court reporter, call me, call the clerk of that county, if you have that information, the judge's office, someone to let them know that you are on your way and you'll be there shortly. Because if gets to be about 15 minutes before, I'll start wondering, is somebody coming? Is there a mix up? What's going on? So it'll just save a little bit of worry for the court itself, knowing that someone is on their way. And then when you get there, just make sure you're real prepared, have your things, whatever you may need to bring with you for the type of reporting you do, make sure you've got everything you need already ready to go. And have your contacts as far as the court reporter, like in case you do need to call them along the way or during the day, but any contacts that you might need, have them with you when you go to court, easily accessible in case you need to reach someone. Just in case, it's better to be prepared and nothing come up than to need to get in touch with somebody and not have that contact. When you first get there, after you get settled in, depending if the clerk's there, what time you get there, all of that, you'll just have to see as you go what's best time for you. But introduce yourself to the clerk. That'd be the best place to start. And if you have a business card, you could give that to her as well. And she'll give you a docket, or they could have already left one on the table there for you. And that docket will be for you to take with you. And if you have any questions during the time that you're there, the clerk is a good one to ask different questions that might come up. Or at the end of the day, to get your form signed by the judge, you could give it to them if the judge gets out before you're able to get it signed, and she'll get it signed for you and get it back to you. And then also, if someone from the DA's office comes in, you could also introduce yourself to them. And from the PD's office, usually they're the public defender's office, they're usually some of the first people that get there. You could introduce yourself to them if you have a business card. You give one to them as well, because they need a transcript from the day, or somebody does, they'll have a contact person to be able to get it, to be able to get that information to you. And also the clerk will have it. So usually they'll contact the clerk, but if they have your card, they may contact you from the DA's office or the public defender's office. Anyone else that would need a copy of a transcript or the original, whatever, they would contact the clerk, and the clerk would get in touch with you. So depending on what time you get there and all that, make sure that you get the system tested, make sure everything's working good with it. And, if you have any issues or anything, then you can just let me know. And then also have BIS's information available where you can reach them by phone if it's something that they may need to assist with. And that's also later in this, you'll see it. If you don't have it, you can write it down from there, or I will put it on some other information that I'll have available in case you don't watch this by the video itself and just audio. But I'll send that to you. Just let me know if you don't have it. They also have their support at bisdigital.com. And you can also send them an email. And usually, I tend to see it's Shamar, usually, who will get back with you, but somebody will get back with you pretty quick and try to arrange like a time and things to call, or to see if it's a good time to call. And he can help out with that as well. So then you can set it up, get ready when the judge steps in or right before he steps in, and hit record. You can use pause during the time and then restart and not stop necessarily. But and if you haven't had the training on the BIS equipment, then let me know and I can send you that link as well. And it'll give you the process of what to do for record and to get it to record, because there's could be a different step in there that you'll need to do to set up the actual recording. It'll walk you through that. When the judge comes in at the first of the day, they get ready to start the docket. Everybody will stand. Every courtroom I've ever been in, they will stand, and then they'll open court. It's a good idea to do that as well. I know some courts are more formal and less formal than others. Some courts, they may stand every time the judge goes in and out, and just different things. Or they may say, remain seated, and you just kind of listen to what they tell everyone to do, and you can do the same. I would stand when they first walk in the courtroom, and then, sit down and be ready to go. And part of when you're in there, one of the biggest responsibilities of the court reporter is to protect the record for appeal. So there's different times when you may need to speak out during court. Even if it's not something you think you really like to do or anything like that, you just have to look at it as the fact that it's up to the court reporter to protect the record and make sure things get in the record. The attorneys make the record. The court reporter just takes down the record, which is huge responsibility. So it's not it's definitely something big, but something that you're trained to do and something you can do. So if someone starts talking really quiet and you need to ask them to speak up, feel like you can do that. If they don't give audible answers and keep shaking their head, well, everyone in the courtroom may be looking at them doing that, and they know that they mean either yes or no. But if you do the transcript, there's not going to be an answer in that spot. So you would need to say at that time, please answer audibly, and then get them to answer out loud. And then a lot of times the judges will be watching for these things, and they'll do that on their own, which is great. Or if they see you do it a time or two, usually they'll take that over and do that, because it's not something you want to keep having to do over and over. And usually either the attorney or the judge will help to do that, and then they'll just straighten out. Same thing if they're talking over, things like that. You can let them know, I'm sorry, I can't get both of you talking at the same time. And I say these things as if it's something you have to do all the time, and it is not. It shouldn't be. It should, but it does happen. So it's okay to do that, because another part of that is if that happens, like people talking over, things like that, if that does happen and you've let them know about it and ask them to please not talk over each other, or whatever way you're more comfortable saying that politely, then because in your transcript, you may end up having to put inaudible, crosstalk. You may have to put some kind of term in there for that, because, you won't be able to get certain parts of that if they keep talking over each other. And that's why you need to let them know. And some courtrooms, the judges want you to look to them and tell them. if it's the witness who says it, you could just say, because they just answered it, so you would want to try to catch it quick. You don't want to wait and have to go back 2 answers later. But if they keep doing it, you could look at the judge and say, "I'm sorry, I can't get that," if they keep talking over, and let the judge straighten it out for you. But it definitely would be something that you need to do because they're looking to you to get the record. And when you have to put a colloquy in there that you weren't able to get that word, because we are verbatim court reporters, that's what we're there to do, then you would have built right in the record the reason why you could not. And also that you let them know that you weren't able to get it and you asked them not to do it. So it just kind of covers yourself as to why that would be there if they continue to do that. So it's for yourself and for the record and for everyone and for the Court of Criminal Appeals. If it goes up on appeal, that'll show why. That it's not you missing things, it's that, you're having a hard time, even though you're asking, that they were doing the things that made it hard for you to be able to get that word that they were talking over each other with. And another thing is, I actually got this from a witness that was in there that was a detective. And I thought about it, and it's really true. If the judge ever asks you if you want a break, it could be them that's needing a break too. So if they ever ask you if you need a break, it's fine to say yes, just a quick break or something like that. That way, in case they're doing it for your benefit, then you'll still get a quick break. Or if they're doing it for themselves and they need a longer break than you do, at least they'll have their break too. So I think that is a good idea if they say, if you want a break, even if you think you may not need one, it might be a while before you get another one. So it's probably a good idea to say, yes, thank you, real quick would be nice, or whatever words you want to use. The clerks, when they're in there, their purpose is they actually keep up with the records, everything that's introduced during the dockets, and they hand stuff over to the judges. If they're doing like motions, things like that, motions been filed by the attorneys, they'll hand that over to the judge as the case comes up. And then, so they're the document record keeper for the court. They also read off the dockets, and that would be the best person to ask different attorneys' names. They should be on your docket under under the DA, and then also under the defense attorney. But just in case somebody else stepped in, usually they'll tell you. But if you didn't get it, or you're afraid it's an unusual name, you won't be able to get it, then just ask the clerk. Write yourself a note, circle it on your docket, whatever, and then just ask the clerk about it when you get a chance. But they'll read that docket off. Also, if something is read into the record as far as like part of an exhibit, or say it's even a CV of a doctor where part of it's read into the record, or not even read, but they ask the doctor and he may talk about it, or say it's something from a technical report in the form of an exhibit, then that's something you could also get from the clerk later. If it's just a few words you need to get on a break, you could get it during that time. Or if it has several things in there you need, you can just ask them if you can get a copy of that. And then you can go ahead and just put it with your docket. And if a request comes up for the transcript, you'll already have it in there. If it's something you know you're going to need, and most likely a transcript will be needed for it, then you'll have it. And that's the same thing as far as like an exhibit list. A clerk, you may keep up with your own exhibit list there too. And of course, the clerk does, and that would be like her list would be the official exhibit list. It would be the one used for appellate purposes. In some counties, it may come back to the court reporter. If they actually give you the exhibit to mark, then you would be the one making an exhibit list. But if you're not and the clerk does, then you could also get a copy of that. That's usually if it's a trial. So after the trial, before deliberations, some kind of break in there before closing argument, some kind of time when there's not um, going to be more proof put in the way of exhibits. You could get a copy of that, or you could just borrow it and write some things down because you will want those, the way it's labeled on there, you're going to want that to match your transcript for your exhibit listing in your transcript. So it's just an easy way to get it really quick while everything's already out there, right there in front of you. You can go ahead and get it, put it with your records, and not have to think about it again. When it comes up, if they're found guilty and it's found goes up on appeal, you can just pull out your docket where you've got those documents there, and it'll help you be on your way to get it to start preparing the transcript. And there are times when they may use some unusual case sites and stuff like that. If there's some that you think may be hard to find the spelling, if it's during a break or something like that, you could ask the attorney who used that case site and get the spelling from them from then. It's not something you want to, ask them 10 things a day or anything like that. But if it's something difficult that you think might be hard to find, then it could really save you some time later. It just depends on how the court date goes. You don't want to interrupt court, you don't want to slow it down or anything like that. But if the opportunity comes where you can ask them, then you can do that. And if not, that kind of works like if it's also on trial and there's a break, you could ask them real quick. But and then write it on your docket where it'll all be right there together when you pull it back out later. And then if not, there's a lot of different ways to find the case sites besides even with the name. You can put it in best you can, and then also put some other things with it to look it up, the case number if they give that out, and some things like that. That'll help you also be able to find it too. And the judge sometimes back behind in chambers or something, some may, I never have, but I've had one or two that's said to call them by their first name or whatever, but I never have. It's just been a matter of respect to me. If nothing else, I just call them judge. If I don't say their whole name or make it the whole formal everything, I will at least say judge. It's just, I feel like that's respectful. But back behind in chambers, what they tell you to do and what you're comfortable with, that's would be something totally different. But when you go in the courtroom, it would definitely be judge, whatever their name, your honor, that type of thing. It wouldn't be no more referring them by their given name. And when they do come in first thing, we kind of covered that a second ago, do stand up when they come in first time of the day. And also, if it's jury trial, when the jury enters, to stand. Some of these things may be different from county to county, and you just have to kind of see how they do within their county. But it's something at least to kind of be on lookout for. Because, like I said, some courtrooms are just a little more formal than others. The rest of the day, you just follow the lead of the court. For instance, if the judge stands up when the jury's in, nobody's talking, the jury's coming in the morning, like at the very beginning, if the judge stands up, I would stand up. But if it's a time when, of course, once they start talking, then you have to be seated and ready to go. And there's sometimes, when you have that chance that you may ask different things, or there could be like just some talk between on breaks or things like that at the beginning of the day if they come in and stop, right away or something like that. There could be some times when there's some casual talk and things like that. But even within the court, judge, the attorneys, whatever, you need to always be mindful of the judge. And when she's ready, no matter what, everything needs to go back to being ready, back to business, no matter what. So sometimes there will be discussions during court, but always be ready to go when the judge is ready. And if the judge is in conversation with you, let them be the lead and be ready to go. You can kind of tell when they're ready to get back to business and just be ready to go. One of the things that makes court reporters vital in the courtroom, in criminal court especially, is the ability to be impartial in all cases and everything. Because it's whether defendants, attorneys, no matter whatever the defendant is there for, everyone is innocent until proven guilty, as you hear the judges say. Everyone needs to be fair and impartial, be respectful to everyone that's in court. If you find that you may have a possible conflict, maybe you know the defendant, maybe you know someone in someone of their family, you can let the judge know about that. Just so, because it's not something you want to come back and do later. You need to let them know up front in case there's something they think they may just need someone else to come in, another court reporter come in to do it, depending on how well you know them. Of course, you may not know because you don't know what else is going to be on the docket sometimes until you get there. So, but you do need to let them know. And then at all times, it's important to keep things confidential within the case itself, just within the court proceedings. There are things sometimes that become very public and on the media and all of that, but it's not for the court reporter to start those kinds of conversations and to go into details that's not on TV and all that kind of stuff. It's not something court reporters need to do. And if attorneys ask you, any of them ask you in the courtroom, ask you on either side about opinions, comments on cases, it's something that court reporters need to keep within themselves and not comment one way or another because it could look like they're not being fair and not being impartial. It could make them look like they're hoping one side over the other comes out, with either guilty, not guilty, whatever. And the court reporter's there to take down the record, and that's the purpose of them being there. You just don't want no kind of appearance of impropriety of like being a buddy of one of the other of the attorneys or nothing like that. Because even the people sitting out there can give them the thought of, oh no, they're friends with so and so, so this record's probably going to be slanted towards them. It's not something you even want no one to have that kind of question in their mind about. Being friendly and nice is the same everybody that's in the courtroom, just being respectful. And if you ever need help with the transcripts or have an issue or something like that, just ask for help. There's no judgment, nothing like that. Sometimes we just may need help, and it's a good thing to ask for because although everybody's out there in the counties, you're not by yourself. There's many other court reporters all around you that are willing to help you, and I'm willing to help find someone who can assist you, or depending on what it is, if it's something I can help with information-wise, then I'm sure willing and happy to do that anytime. Another thing is, not that I think this goes on much or anything like that, but as far as attorneys or parties or anybody like that wanting to give gifts of monetary value, things like that, that's not something court reporters need to be involved with at all. Same reason, because it can look like it could be not, they may not be fair because they give them gifts. It's just an appearance of impropriety that court reporters don't need as they just continue their work. It comes down to this. The court reporter's work is meticulous work. It not only chronicles legal history, but also serves as a foundational element upholding the very essence of integrity, transparency, and fairness within the judicial framework. Absolutely. Another very important reason that court reporters are in the courtroom is to be able to show the fairness, the transparency from their verbatim transcripts. And the judicial framework is the reason they're in there for the purpose of appeals for defendants if they're found guilty, and even just different issues that come up during the case itself, that there may need to be question of law, an appeal that goes up before it goes to trial. All of that. That's why it requires the hard work that court reporters do to be able to produce that record so that it can go up on appeal with appellate judges knowing it's a verbatim record by someone who has nothing involved in the case other than to do an excellent job and produce a record. During court itself, as you're going through court, you have ways that you can kind of be watching your system. If you look over and see course through confidence monitoring, that you can pick up the headphones and listen through when you first started up the day to check on the microphones. And that is in the BIS training, that it explains how to do that if it's not something you've done before and you want to be more aware of how to do that. And that's something that will, just to make sure that everything's working the way that it should. And if you come across any issues at all, then just let us know. Even when you file something with BIS, you call them. If you send them an email, if it's not something they take care of right away, and it's something that leaves an outstanding issue, let me know as well. Send me an email or text or something so I can help you follow up with BIS to make sure it gets taken care of. If it's something not within the system itself, it could be something within the computer, like the hardware part, the disk drawer, something like that's broken. Then that would be something that we would go through support at gncourts.gov. It would go through them that you would report that. And that's also written down in some other things. If you don't have that, just let me know and I will send you any of this information as well. As you're going through the day, and you kind of keep an eye and you see like the channels moving and all that kind of thing, you know that the recording's working for your backup. Then as it's going, you make different bookmarks. And I know it's maybe done a little differently between machine writers, pen writers, digital writers, voice writers, all of that, maybe a little bit differently. But on the bookmarking, whether it's Court Smart or BIS, just add in some bookmarks in there. And that's also for the judges, the law clerks, if they ever need to pull something up and look at it really quick, or say like if they've got a ruling under advisement, they may want to go back and be able to find something to listen to. And so those bookmarks help them also. It'll help you when you go back later. If you need to pull it up by that, you'll have that on there. And so it's on there for several reasons and also for years to come. The recordings are there for years to come. And if someone ever had to come back to them later, say if something happened with a court reporter and they retired, no longer there for any reason, then if someone else had to step up and be able to produce that record, it would help them to have that, the spellings of the names and things like that in there. Objections, bench conferences, witness names, those type of things, just kind of bookmarked in there. And as much as like with digital reporters, I know most of y'all put in a lot more than that, and that's good to have as much as you can get in there for that. But everyone needs to be doing some bookmarking on there for the judges and for the record to come is the main reasons that we do that. And if you need to go back as well, it'll just be an easy reference for you. Also, I've had some digital reporters talk to me about this, and it's a really good idea. They had mentioned like the lower type of keypad, little keyboards that don't have the taller keys, that they're quieter keyboards. If you don't have one of those that you can bring in, let me know, and I'll see if we can get some of those, because I think that would be a good thing. It would be maybe make you be a little less self-conscious about hearing the noises during different parts of trials and things like that. Some may have courtrooms with other things going on in there where it may not, bother you as much. And some may be so, so quiet that, it just kind of makes you self-conscious. So that is a good idea. Someone had mentioned that. And if you don't have one or can't get one, whatever, and you want me to see if I can, just let me know and I'll see if I can do that as well. I think that would be important to do. And the backups itself, through the end of the day, you would make a backup, give to the clerk, and then keep one for yourself. On the backup that you give to the clerk, put the judge's name, the date, the courtroom that you're in, and put your name and phone number on it as well for the one that you give the clerk. Just in case your card falls out of the file, whatever, then they'll be able to pick that up for the day and know who was there, and they'll be able to get that to you quicker and let you do the transcript if a transcript request is made. And then as you go through the BIS training program, or if you've been through it, also you want to download the DCR player so you can play the CDs later. I thought this is a good time to put in and say this often. I think I used it in something else recently. The court reporter is a silent hero of the courtroom. Most of the time, court reporters are there and they are quiet. You hear much from them unless they absolutely need to clarify the record. They do that, but their job is so important for them being in there and everything that's around it, being able to produce a verbatim record. It's irreplaceable in that way. They're the only ones who can have things clarified as it goes and produce a verbatim record and be unbiased and be able to have that for the Court of Appeals so they will know exactly what went on, and to be able to clarify things that come up where people aren't speaking out loud and be able to get them to speak out loud so that it will be on the record, because that's something that a court reporter can do where just a recording by itself cannot. It takes the court reporter being in there to be able to produce a full, complete, verbatim transcript. With transcripts itself, if you're watching the video portion, I have on here attached protocols. What I mean by that is if it's a new reporter and maybe no one showed you exactly, but there are certain standards for the Criminal Court of Appeals where like your margins are set, the number of lines per pages, and a lot of it's similar as civil too, but it also tells you how many spaces over indents allowed and things like that as well. I do have a listing of that. I'm happy to send that out to anyone who doesn't currently have it, and I will attach it to the audio or video when I send it out by email. I can attach it to that as well. If it's something that you would like to have and it's not attached, then let me know and I'll send it to you. But some of you that's been reporting a while may not need it, so that's fine. You already know because you've been producing transcripts. And on the deadlines and times and stuff like that for transcripts, when somebody gives you a transcript order, just go ahead and ask them if they don't have it filled out on the request itself when they would like it by, or if they give you an order, because some counties only prepare transcripts from when they go to the judge does an order and gives it to a court reporter. Ask the attorney when they would like to have it by, or if they have a hearing coming up, stuff like that. That'll help you to hopefully prevent some of these coming to you the last minute where they never mentioned, when they wanted it by. And then now it's kind of, they're needing it right away. That may help with that. It also helps with your own scheduling of your transcript time itself. So you can do that. Just ask them when they need it by. And of course, with the appeals, we know those are 60 days. And some clerks write it on there and some don't. But if you don't know exactly when that is, I would just go ahead and check with the clerk and get that date, because you want that. You don't want it to sneak up on you. So you can use it for your planning of your transcript preparation time and all of that. Your names and addresses, whatever research you need to do to be able to get those, you would need to do. For the appeals itself, it's going to be on there. For the orders, if the attorneys had to ask for it through an order, a motion and order through the judge, it'll be on there. Get that too. And then, of course, internet wide gives us a wide, just so many ways of being able to research and find things. And we want to make sure we're using reputable resources as well. Either ones for local attorneys, through the American Bar Association. You can check out the public defender's office within your county. Some of those have it on their websites as well. District attorney's offices, they'll have those too. If you have any questions concerning any of this, just feel free to ask. You can ask someone local in your area, or you can ask me, email, call, whatever you want to do. And in your table of contents, I know people do this differently. I do believe that I probably put more on mine than some people do. It's just the way I was taught. I was taught kind of more old school type ways, I would say, to have everything pretty much included in the table of contents. It just doesn't leave a question if they're going to look for something. Especially you want to have like your preliminary remarks, if it had any kind of motions in it, stuff like that, pretrial motions, you'll want those marked, even if you group them together. You'll want your witnesses, the cross, direct, cross, redirect. Not everyone does, but I think it's a great idea to put in there any objections that's made, and also bench conferences. And the reason for those, especially on appeal transcripts, because when the Criminal Court of Appeals, when they're looking through that, the appellate judges, it will give them quick references to go and review certain things or to go back to. Even after reading the transcripts, they'll have that marked, and it's easy for them to go back in and be able to get that. And also on there, if you do transcripts and it's done by a recording that you've done, in there, whether it be on the front, depending on how it is, say like it's a recorded interviews, you would put on your cover page, recorded detective interviews, like that. That lets the person know right off the front that you weren't there. And then maybe at the bottom, put prepared by, something like that, instead of just your name as you would normally at the bottom. And then on your certificate page, also, that would be something that you would need to put on there too. I may mention this again later, but you would put on there that it's done to the best of your skills, ability, and as to the quality of the audio. And you could also put on there that it was delivered to you by recording via flash drive, that type thing, and done and prepared by the best of my skills, ability, and as to the quality of the audio. That way, it also lets them know that this was done by audio, and it gives you, because there may be times that some things are hard to hear because there was no one there, as in like when you're in there in criminal court to tell them, hey, I can't hear you, or whatever you need to say in a polite way, respectful way. But there's nobody there to be able to help out with that record. So in those cases, you may have some inaudibles and some things like that. So that's kind of giving them a heads up too at the very end that this is why this is in there, because, I wasn't there. Nobody was there to be able to help out with the record. So that's just kind of saying that's why this is in there. That you did try the best that you could going through the recording to be able to pick up every single thing you could, but this is why if there's something that's not. And then different times during hearings, during trials especially, there's times when you're going to need have colloquy and parentheticals and things like that. The colloquy would be when you go over and space into the middle, and those guidelines are on the transcript guidelines for that too. But you go over and space in the middle. It's conversation between judge and attorney. It's not your normal question and answer. And then your parentheticals would be when there's an explanation, as in like whereupon the witness exited the stand, or whatever terminology that you use upon that for those type things, whereupon the jury entered the courtroom, things like that, whereupon the following proceedings were held in the presence and in the hearing of the jury. Same thing, whereupon the following proceedings were held out of the presence and out of the hearing of the jury. If it were a bench conference and they go over and you have your colloquy, your parenthetical for your bench conference, you would put on there, whereupon the following proceedings were held in the presence but outside of the hearing of the jury. And those type of parentheticals are very important, because when the Criminal Court of Appeals reads that, if it goes up to them, if those type of parentheticals aren't in there, it looks as though, reading it straight from the record, that the jury's hearing certain things that they should not be hearing. And that's the reason why we have to be extra careful to make sure those parentheticals are in there. I use the whereupon. Not everybody does that anymore. Like I said, I kind of, in my first full-time criminal judge, was kind of a more formal type judge, and he liked things like that. And I definitely did that because of it was just in his nature to be more formal in that way. The transcript itself, when you look at it and think about it, it has to be like the Criminal Court of Appeals when they read it. It's almost as though you're taking a record sitting in court with your eyes closed, basically. When they read it, that's what they will be, because they won't be able to know things that's going on in the courtroom. And that's why sometimes we have to put little things in there. We don't interpret anything about what's going on in the proceedings. That's not for the court reporter to do. But what you have to do sometimes is have clarifications. Say if something happened really quick and they went from one question to the next, and there was no, if there was no time, it would be one question after the other. But say if there was a brief time, but the witness never answered, you might have a no audible response that goes in there. Say if they're pointing at something or indicating to something, which makes it make sense to the next question or whatever coming up, then you may have to just put something like that in there. But you don't say indicating to, you don't say whatever, you don't refer any of that, because that would be interpreting. And we're not there to interpret. It's just there to clarify something for the record. So it makes more sense, because they could go on to the next sentence and it wouldn't make any sense at all. We wouldn't be able to tell anything that happened during that time. And it could also even lead it to look like something different happened. But like I said, you don't say, don't describe in no details and none of that kind of stuff. It's just for clarifying only as to pointing or things like that. Another thing that's really important is when the defendant comes in at the beginning of the day, a lot of times the judges will say something to them when they walk in. But if nothing's said and they're on the record and they come in, then you need to go ahead and just start by the defendant entered the courtroom, put something in there. If they leave, say something's going on, there's conversation, things going on, motions, whatever, outside of the presence of the jury, but everybody else is in there, and say quietly the court officer takes them to the back to go to the restroom or whatever, then you need to put on there whereupon the defendant stepped out of the courtroom. When he comes back in, make sure you put another parenthetical on there that they're back in the courtroom. Those type of things. The defendant being in and out of the courtroom is really important. You don't want to forget and not put them coming back in the courtroom if they had to step out. Or if they say on the record, do you need to step out? And they say yes. and then you never show them coming back in as far as the Court of Appeals goes, they wouldn't know that they even stepped back in unless that's on there. Just something to think about. You have to just really look at it through the way that you read it instead of necessarily everything that you're seeing at the time. So what you're seeing and what's not spoken is another important part of why a court reporter's in there, because it needs to be in there for the purpose of getting a full and complete record. So it's just another reason to keep in mind things that might be very important that needs to be on the record. Other things that will be used for like parentheticals would be exhibits. And on exhibits, one thing you need to be real careful with that. Some people mark it whereupon exhibit number 1 was entered, whereupon exhibit number 1 was marked and entered. Those are small differences on that, but sometimes they're marked for ID. If it's marked for ID, whether you put whereupon exhibit number 1, curriculum vitae of Dr. whatever, was marked for identification, whatever. It's more going to be other types of reports or pictures, maybe that's going to be introduced from a crime scene tech like that. And then at another time, they may be introduced as an exhibit. So I think that's more like the kind of time that something like that would come in. But you need to mark it for ID only. If they say ID only on your parenthetical for that, make sure you put ID only. And then same thing on your exhibits, on your exhibit list, mark it for ID only as you mark your pages for that. And then when it's marked into evidence later, put on your exhibit page underneath that when it was marked into evidence and then the page number for that. And then at that point in your transcript, it would also have whereupon exhibit same number, name, if you list the whole name out, was entered into evidence. So same thing, or otherwise it would look like it was made for ID only. Every once in a while, they may have exhibits that are entered that they want under seal. If it's an exhibit under seal, then you would need to mark that in the exhibit line when you put whereupon exhibit number 1 was marked under seal. On your transcript, through your exhibit page, put the same thing, exhibit number 1, and put whatever under seal. You want that real clear for everything, everyone. And of course, the clerk or the court reporter, if you're marking them, there's a special way to handle those types of exhibits. That's so if someone was to come up and want to get in the file for some reason, those exhibits are kept under seal. And so it's really important to put it like that in your transcript as well, to make sure it doesn't get mixed up in any other way. Now, there's other times that you'll have parentheticals, and some that I probably may not mention here too, that I may be overlooking. And if anybody thinks of anything they think I need to share, just please let me know. I'm happy to do that. But like when a witness is excused from the witness stand, when there's a bench conference, when there's a recess, when the jury goes in and out of the courtroom, and things like that. I think you're getting a good idea of how that is. At the end of the day, when they leave, you put that it's dismissed for the day to be reconvened at if it's coming back the next day. That way, when the transcript is read, it's known that, okay, this isn't the last day, which it wouldn't have the other certificates and all that on it as like the last day would, but you can just put that on there because it could be, for whatever reason, it may start the next day at 1:00 or whatever. So it's just to keep an actual record of that, of what's going on with the different parts of the trial and stuff. The same thing when the jury goes out for deliberations. I put on there, jury left the courtroom to begin deliberations at 4:30 p.m., at 1:00 p.m., whatever. And then that way you kind of have that period of time for when they start deliberations. And then at the end of the day, if they come back in, they're excused, come back the next day, then you just to note those times when the jury left for the day. That shows how long they were deliberating for the day is kind of what that's doing. The next day, the judge will say whether they have them come in the courtroom or whether they start deliberating and don't come in the courtroom. The judge will say what time they begin deliberations. Make sure that you also put that in your transcript for the beginning of the next day, what time that they began deliberations. So you'll have a record of it. Like I said, it keeps up with how long they've actually deliberated in case something comes up later. It's something that's in there, something no one would ever have to ask you to go back and try to recreate. You just want it in the record because the length of time could become important. And then let's see. If there's a pause in the proceedings itself and for some reason, maybe there's technical issues or something like that, you could put that in the form of a parenthetical because the fact when they start back, they may not start back exactly like when they left off. So it just kind of lets the record flow and the judge, attorneys, appellate judges, when they read over it, they'll know exactly what happened with that. And then when they come back in with a verdict, you would do that too. The jury entering the courtroom with verdict at whatever time. You would just put a note on there. And like I said, some may use weapons, some may not. That's not important. It's okay if you do or if you don't. You don't necessarily have to do that. In here, we've got the enter. I wanted to make sure we did talk about that for colloquy and for parentheticals to what to do about marking all those and labeling it like we need to do. Some counties actually do exhibit volumes. And I know some in East Tennessee and West Tennessee have talked about doing that. I did come across something that the appeals court has in writing, and it talks about how to do it. I won't go into great length on that, but it is something that we can get to you. And also, there's another really nice court reporter who's in one of those areas who's going to, she said she's happy to try to help with that. So I think we're going to do some kind of little video or something about that to explain it further. And I'll let her help with that because it's something that from being in East Tennessee is something that they do all the time. So, and she's very experienced, been a court reporter a long time. And so she'll be very familiar and can help with that. And we'll get the guidelines too and attach it in there if anybody's interested in that. But we'll wait and go over it in greater detail when we can meet up and be able to do that. But it is actually in a separate volume all by itself. Same thing though, for sure. I say here to compare to clerk's list, but at this point, if you're the one doing the exhibit volume, then you may be the one during the trial also keeping up with the exhibits, and it may be your list. But it's just making sure that they match what's in your transcript, what's listed on your exhibit list too. And on the certification pages at the back of your transcript, there's like a standard one that I think, everybody uses. If anybody needs one, to new reporter, and you need a sample of that, let me know. We can do that. But it would go at the end of your transcript, and it would be signed by the court reporter. On recordings, I talked about this a minute ago, that you would put on there you could put on there transcribed recording presented to me via flash drive and transcribed to the best of my skills ability, and as to the quality of the audio. It's a sample of what you could put on there. You may use a little bit different wording, and that's fine. Generally, when you're doing your transcript, of course, you want to be consistent, with your wordings. I know in some cases it may be okay to use the same word, hyphenated and as a single word. If you decide you're going to do it one way and both are acceptable ways to do that, then just stay consistent throughout your trial and keep it the same way. If it is something that there is no way you can get the spelling, you've tried everything in the world you can do to find it, and you just cannot. And you have to put phonetic after that. The first time it's listed in your transcript, put phonetic. And after that, you don't have to put it every single time if you don't want to. You just keep the same spelling that you've got up there. You've already let them know that it's phonetic, that you've spelled that by, and go on. Of course, it's not something we want to do, but it could happen through trying every way you can. That every kind of resource, documents, everything you've got, calling a friend, everything. It might be that sometimes that happens when you have to use that. And that's how you could do that in your transcript. I just thought that was a neat court building, so I thought I'd put it in there. If you didn't see it, just a picture of a courthouse. I started out, I was going to get pictures of all of the courthouses in the state of Tennessee. I started getting them together, and there were different ones that had rights reserved on it, so I couldn't do it. I thought it would be interesting for everybody to kind of see the different courthouses in Tennessee. Now, with the judges, if it's like you're filling in for somebody one day and it's maybe something you're probably not going to have to do in that same courtroom very much, then necessarily you may not, get a chance to do this. But if you're going to be a designated reporter, especially for starting with being a designated reporter, or if you're one of the regular reporters that's in there, maybe there's two or three of you that swap up, then it may be something you want to do. Say maybe you haven't gotten used to being able to ask for clarifications in different ways. Just remember, it's to protect the record. It's not doing anything else. So if you ever have to, just think of it as that and don't worry about, you having to be the one to do that. But what would be a good thing to do also, because judges may be different, some judges want to handle something like that themselves, where you could look to them and they would want to be the one to do that. But these are the different types of things that might be something you would want to talk to a judge about if you're going to be designated or working in the courtroom very much. Say you haven't been comfortable with saying very much in the courtroom before. You could just explain it to them at the beginning that in making your transcript, the whole idea with it being a verbatim transcript is to be able to get every single word. The only way that it's possible to do that is sometimes if we have assistance from the ones who's putting the information in for the record. So just remember that you're creating the record verbatim from what they're putting into the record. So you can only make the record as good as the way they're putting the information in. But these are ways that can help. But it would be things that you could talk to the judge. If this comes up, how would you rather me handle it? Is it okay if I say, to the witness, please answer verbally, or would you rather me look to you and, let you do it? Those types of things. So points of clarification. Like I said, I've got these listed. I'm going over it a couple of times because it's important, but it's not something that happens every single day. And it's not something that you should be overly worried or concerned about, but it's good to know, how you would take care of it. And the big part of that is to be able to put in the record for your own self. Because there's times, say, you might get an attorney who just constantly talks over the judge, the witness, whatever. So there may be a time at some point, because of them doing that, that it makes it impossible for you to get other things. Well, you don't want that in there, inaudible, indiscernible, whatever, because of the person who's causing that to happen. Instead, you would rather or need to get a point of clarification to ask them to please, you know, please stop talking over one another, whatever terminology you're most comfortable with, and talk to your judge that you work with regularly to see, what they say. Because the thing about it is, at least if you're able to get that in the record, when those times come up, if they keep doing the same thing, then it's got it in the record that you've asked for them to please not do that. And if they keep doing it and it makes you have to have an inaudible, indiscernible, crosstalk, all that kind of stuff, it will explain why it's in there. It's not something you wanted to do. It's not something that you weren't trying to make sure you could get every single word. It's because if that's done and done for over a certain amount of words, it just makes it nearly impossible unless you're able to, between your system, go back, split the channels and pick it out. But then sometimes it's still not even possible to get every single word if they do that too much. And that's what they want court reporters in there for the verbatim record. So it's good to get that clarified on your transcript and written in there just so that it kind of covers you as far as why that's not that way because, of the way things happened in the courtroom itself. So for clarifications, if it's something you need, for somebody talking over, um, if they're not answering out loud and shaking their heads, you can ask them to please answer verbally. If they're too quiet and you need them to speak up and they're giving you trouble, also, it wouldn't most likely be only you that they're, quieter for. The court reporter's going to notice it maybe first or the judge, but, other people are also going to have that same problem. And that might be a lot when it's like a jury selection or something like that. You may have that issue. And it's good, like I said, same thing to let them know because it can cause a problem with your transcript being able to get every single word if they're too quiet, if you can't hear them. And don't rely on the audio to go back and think, oh, well, they're kind of quiet, but I'll get it later. Because if you're not hearing it, biggest chance is the audio is not going to pick it up. So it's better just to go ahead and let them know. If they're doing questioning the jury and the attorneys right there beside you, depending on how your courtroom's set up, it's easier sometimes just to say, hey, can you get them to repeat the answer? Or, I couldn't hear, or something like that to the attorney who's right there answering the questions because they can go right back to it. But a lot of times depending on how the courtroom's set up again, the attorney on the other side might go ahead and say, before you can get it out, that they couldn't hear. But, always feel like you can do that to be able to protect the record. Like I said, these are the kind of things that you could talk to your judge about. If you're in there frequently or if you're the designated reporter in there, just so you know how they feel about it as well. And explain to them, why you're asking, because you're wanting to do a verbatim record to the best of your ability. And part of that is relying on other people in the courtroom. And bench conferences, if they get over there and get to talking and you can't hear them, let them know right away because they'll, have to do something else for that. And sometimes they may end up wanting to go in chambers. It could just be their mic's not turned on. It might be if your headphones are plugged in, but you got to turn up the on your computer, the sound. It could just be something simple like that. But it would be a good idea to also have like a little recorder of some kind in case they decide to go back in chambers to do their bench if something went out on the microphone in there for that. But and with bench conferences, if you're a civil reporter and haven't been in criminal court yet or just getting started, they do have the white noise. I don't know if there's civil courts that might have that. If it's jury trial, how they may do that. I'm trying to remember. It's been so long since I've been in a trial for civil. But anyway, the white noise, if you haven't been in a courtroom with it, is kind of louder. So definitely, don't be alarmed when you first hear it if you never heard that before. And new court reporters, before you have a trial, you'll already know that's what's going to happen when they do their bench conferences. They're going to turn on the white noise, which is like a staticky noise. And at that time, when they go over the bench conference, just pick up the headset that's there, and that way you'll be able to hear them through the microphone. Like I said, if you don't, let them know. It could be whether something needs to be turned on, or you need to go to your settings, like at the bottom of your screen where you see the speaker button, and just turn up the speaker. Or if it's plugged into a speaker, you may have to turn it up from the speaker itself, and then, turn it back down when you're done, because it'll go through the headset, not through the speakers, because it is intended for the jury not to hear. That's why they go through all of those great lengths for it to be out of the hearing of the jury. So it doesn't make them be biased or whatever by hearing something they shouldn't hear. And then if you're having trouble kind of like with an attorney doing different things during the trial, say, it seems like you're constantly having to really strain or something to hear them, just let them know, because they do want to make a good record too, because, they may end up needing it. So they do want to make a good record. And then don't forget to use the, um, I had on your colloquies. I sometimes will do that. The parentheticals, like when you do go in, because a lot of times it'll start out in the form of a colloquy, and then you'll go down to your parenthetical about court reporters saying, asking for a verbal response or something like that. However you do, sometimes it might be in the form of colloquy, and sometimes it might be in the form of parenthetical, depending on kind of what happened in court at the time. Will help you decide what to do. If it's something that you're stating of yourself to have to do, which is not something you really want to do a lot, but if it's something that you've got there, you could do it in that way, to put it in the form of colloquy. Okay, on here we've got Court Smart. That's Mark Como for those in Davidson County. And I think most of you have his cell too. If you have any technical difficulties, he's definitely the one to get in touch with in Davidson County. In BIS, we have their phone number, and I've got all that listed here. I'll just read it off for those that might be listening. And I think I also have the ability to make these into paper printout. So if it's something that you want from here that I can print out, if you get just the audio portion, I'll check on, see if I can do that as well. So for BIS, one thing I think is really neat on their newest training video that they sent out, down at the bottom, it's got quick start guides, or like just shortcut versions of being able to use the recorder and being able to use the player too. So if you haven't seen those or would like them, I can send you the link for that. It's on the bottom of those printouts, or I'll see if I can also save it. If anybody's interested in getting those and doesn't want to necessarily get the BIS training, maybe they've already had it, let me know and I'll save those printouts and send them to you for those shortcuts. But BIS, the phone number is 1-800-715-1234. You can also reach them at support@bisdigital.com. And that would be for like software issues and kind of issues with the recordings and stuff like that. And if you go to the support, bisdigital.com, you send them an email and they'll ask you, it'll be a little thing you fill out about your county and all that. They'll get you to send that in there, and phone number and when's a good time to call. But you can use either of those two. If you can't get on the phone at the time, but want to go ahead and report it, and you can use that. And then also my contact info, which I think everybody has, but it's lisa.angel@ncourts.gov. Phone number 615-741-2687, extension 8735, and my cell 615-604-8698. So every morning you'll be starting those recordings. I know some court reporters may have their own very own system and do everything through their own system, and that is fine to do. You can do that if you feel most comfortable with that, but we need to make sure that it's all on BIS equipment as well, recording and everything. And the logging needs to be done on the BIS recording, which you'll get a copy of that too. At the end of the day, you'll get a copy of the recording to take with you. And same thing, there may be some steno reporters that may even have a recording function through their machine. They may be writing real time to their laptop, things like that. But we still need the recording that's in the courtroom. And that's, like I mentioned earlier, that's for future use, is what that is. Somebody retires, all kinds of reasons that years to come, somebody may need to go back to that and will need to have access to that recording. Someone will. And they'll sure appreciate it if you made sure it was a good recording and all of that. And make sure to make the notations for reference for the judges, for yourself, for years to come, like I said. At the end of the day, you'll make a backup CD for the clerk and for yourself. And some counties may have a place to store it, and some give it to the clerk. If you don't know, you can ask whoever you're filling in for if it's not your normal courtroom, and they'll let you know what their normal procedure is. Also, if there's anything different, y'all, and you've got somebody coming in to fill in for you, something different about your courtroom, anything that you think might be important for somebody stepping in there new to know, go ahead and share that information. It'll just make them feel that more comfortable and make things better for your judge and everything too, if it's something you already know. But on the disc, what you do is write your name, phone number, judge's name, date, and the courtroom on the CD itself. And then after it's copied you can just check it, make sure there's an actual recording on there, because sometimes there's bad CDs that won't record. Maybe you think it record, and it might be a really long time before we ever find out there's no recording on there. You can also tell looking on the back, you can look at them and tell too, but make sure that the recording was good and that there's something on there. You need to find that out sooner rather than later. Okay, and this is a little part about invoicing and things. We are getting much closer with the new system, and there'll be some emails and different things come out about that as we get closer. But for now, when you turn in your invoices, one thing and if I send you a copy back, maybe you had to make a change or county made change or whatever, and you see that I've rewritten over the case number, it's because they're having me do that for every invoice number that comes in for transcripts. But when you write that on there, it's your initials, case number. If you've got more than one invoice for the same case number, don't forget to put the -1, -2, -3, whatever, for how many other invoices you've got in that case, or else it'll be sent back for a duplicate invoice. Don't put a space between your initials and the case name. And the case number, if you put dashes between the case number itself and some don't. That can be either way. And for your per diem court invoices, it would be your initials, space, and a date. The date that's going to be on there is the last date that's on your invoice. So even if you don't have court on Thursday or Friday, your last day of court was that Wednesday, that'll be the date that goes on there. So it's the last date that you were in court. It's the date that would be on there. And mileage is still at 0.67. I've got a few forms that's still coming in with the other rate, just to kind of remind everybody to do that. And then still make sure with our new Outlook feeling good and everything, but still make sure you get that confirmation that I received your invoice. I don't want anything to get lost. And if something happens, we want to know about it as soon as possible to not cause any delays. And if you are taking an order, something that you've took an order for, then just make sure you do get the date that they want that by, so it just helps with your scheduling. And then as far as the invoicing goes on those, if it is public defender, indigent, defendant, then you would send in your transcript invoice as usual. If it's a privately retained, if they're not indigent, then and you send out invoice, it would be your own invoice you send that out for, and you charge your own rates on that. It wouldn't have to be the AOC rates for private attorney. Same thing for private attorney for copies. If you're sending them a copy, it's not required for it to be 50 cents a page for copies. That's just AOC rates for indigent defendants. If you're sending out an invoice to the district attorney's office, some of the district attorney's offices are now within our state system. So when you do the invoice number on those, make it be your own type invoice number. Don't do it the same as like your initials, case number, that type of thing, because it'll show up as a duplicate invoice. So you want to have your own invoicing sequence system for invoices that are not for criminal court. We've had some records requests, and I know some things have changed with the public records and all that. If you get a request for a recording, I know there's two different types, public records requests, and then also somebody just wanting a copy of a recording. You may get that come to you. So what would happen if somebody comes to you with a request? If it's a records request, you could even send it to the clerk, for records request, but they should be following the same procedures as we are, as far as the judge needs to okay it before it's sent out. Same thing if a court reporter gets asked for a copy of a recording, then they need to clear it with a judge, because the judge would need to be, according to the last case that came back from the Criminal Court of Appeals on that, from actually the Supreme Court, is that if the judge, unless the judge says there's a reason not to release the recording, if it's then it needs to be released. But if the judge says no, because there's confidential information, maybe their mics in the courtroom are so sensitive, it's going to pick up other things that doesn't need to be heard by just everyone. Maybe the defendant's mic at the defendant's table is really sensitive, where it may pick up other stuff too. Then, there's different reasons like that where the judge may say, no, we can't get that out. Maybe it's a type of a case with a child that they say no. There's different reasons that the judge, if they think there could be confidential information, attorneys talking to their clients, just other things on there, then the judge can say no. And that's what that case is about. And anybody wants a copy of that, I can send you that too if you want it. But the judge has to be the one to say it goes to the judge. And that's how that's going with that. Okay, now we've got some questions. I'm sorry, I'm keeping y'all for a little bit. I'll try to move on with these pretty quick. And if you have anything else that comes up, feel free anytime to reach out and just let me know. But we will have like some new court reporters as you go out. Just feel free anytime to ask questions, because there's going to be a lot of things that other reporters you're filling in for, or things maybe we didn't talk about that's going to come up. And, we just need to get answers to any questions you have. Any questions are fine to ask. Don't worry about it. If you think, oh, I should know about this, don't worry about it, because that's how we learn, by asking questions. It's fine. Ask questions anytime. And for transcripts itself, I kind of covered over the DA invoices and the type of things like that. The reasons why sometimes you may do your own invoices, or times that you will send it in otherwise. And Rule 13, I kind of did the whole thing on Rule 13, so I won't go on and on about the Rule 13 type things, but that kind of leads its own separate questions on those. but it is things that needs to be pre-approved and things like that. And I am the one who gets those invoices on those as well. And on here, if someone requests, say it's a co-defendant, and they also need a copy of the trial transcript, whatever, then they would get that at 50 cents a page. And they may also need another copy sent, say they do separate appeals. So they also need a copy given to for your clerk or to the criminal court appeals, whatever your filing procedures are. And you have to make another copy. Then that would be 50 cents for that as well. So, you are allowed to do that. If you have transcript requests come in that the judge wants you to do, then you are allowed to charge for that, as just like an attorney asks for a transcript, because it would be a new original transcript that you would be doing. Okay, then we've got, if you come up with and have to change your address, or if you've forgotten to change it, then just let me know, and I'll need to send you a new W-9. And then after you fill that out, I'll send it to accounting. And if it's possible that you may do some Rule 13 things, I will also send it to them. And they may send you back an email saying you're set up. And that's what that would be about. As new reporters come in, I'm going ahead and getting them set up in that system because it goes through what they call a cap. So it's got to be, you have to be set up in both systems for that. They handle a lot of their stuff manually, and that's part of why it makes the time be longer. But don't forget to send in those change of addresses, though. If you just change an address on your invoice and don't do the W-9, and it's going to kick it out, and then it's going to be sent all the way back for that change. So once you change your W-9, same thing. Make sure all your new invoices coming in have that new address, or it'll kick it out if that doesn't match it. That's one thing that'll kick it all the way back out to, slow it down by a few days if that happens. But sometimes things happen, and don't worry about it. Sometimes it just does. As hard as we try, sometimes things are just going to happen. We'll just do the best we can to take care of things and take care of them as quickly as possible. When something does pop up, we'll do it. And say you're working in court some now, but you would like some more hours, or you're going to be moving to a different area or things like that. If you want to let me know, then, I will try to help get you in contact maybe with some other reporters in the area and things like that. Or if you decide you want to start helping out in some other areas, I can get you added to the list for the court reporters when they're looking for someone in the area that's willing to help out. A lot of y'all will just try people within your own little associations within areas to try first to see if y'all can help. So just, let me know, and then I'll connect you with some other reporters in that area and send out a new list with different reporters that want to be added to list in those areas and help each other out in those ways. Y'all do really great helping to cover each other, and I really appreciate it because y'all have contact with, some of y'all have contact with each other so easily, even in group text and things like that. It just helps keep things covered and keeps criminal court going. And I really appreciate it because every single time somebody needed to make a change, it would be hard for me to get everything covered all the time for all the things that y'all take care of on your own many times, and I appreciate it. And if it comes down to needing help, just let me know, and I'll definitely send out those all emergency emails, or I'll try sending out text messages first to see if we can get people in the area. If it starts to get closer, you definitely will get those emails, and I'll try to, as one reporter suggested, putting which area of the state it's in. I try sending them straight to those areas first, but I have sent them out wider, and it's odd because I've had people say, I just happen to be whatever. So sometimes it works out, where somebody can help out that they may not it wouldn't have been someone that I could have thought of. Or I have a relative in that area, I can do it, things like that. So I appreciate it though, because you all help so much and I really appreciate it. We've got some reporters as they start from time to time that maybe just want to come sit in. Say they're a court reporter who's been in civil court, even been a court reporter, have a lot of experience. But before they start, it's good to have them come in, um, just to come in and get familiar with everything, talk with another reporter that's in the courtroom, and just get familiar with how criminal court is different from civil court because there are some differences. And just even the feel of everything and how it works. I think that's a great thing. So if you're willing to do that and want to let me know if new reporters are starting to come in, and some, because of different requirements, maybe there's certain amount of hours or things they may need to come sit in. Some that haven't worked in court at all, may need longer time to sit in. And there's just a lot of different reasons it could be different, but definitely that experience is helpful. And I've been really happy to see that court reporters coming in, even with a lot of experience, really do want to do some shadowing. So they're totally comfortable and ready to go and feel confident when they start court, which is really important just to see, because there's so many cases that come up in there. Whereas in civil, most of the time, court reporters are hired for one case, no matter how many's on the docket for that day. There was one thing I kind of skipped over. People want to know if somebody asked about misdemeanors or general sessions or something that they're requested to do. Well, if it's a misdemeanor going to be held, only misdemeanor trial, say, indigent defendant, if their attorney really thinks they need a court reporter there, he can file for the Rule 13 for that and get it pre-approved for a court reporter to be there. It might be that the judge wants a court reporter there, and it would be on what they would consider like a more complicated case, because what's different with the general sessions cases and the misdemeanor cases is that if there's an appeal and if there's not a record of it, transcript, then what they have to do is they have to get together and have statement of facts. They send it to each other and they have to agree on it, and that's what they base their appeal on. So if it's of what they agree, and then but if they think it's going to be complicated or they think they're never going to agree on everything, they may request ahead of time to get a court reporter for that, and that would fall under a Rule 13 proceedings. And then also, for the DCR system, if you're new to that or a new court reporter and you don't have a foot pedal, never done any transcription of any kind, then and if you need a foot pedal for the DCR software, just let me know, or Court Smart too for the foot pedals for the software. Let me know because I can get those. Even if we run out, I can get more. Same thing as headphones. If your headphones go bad in the courtroom, let me know. And if we don't have them, I try to keep some in stock, but I just have limited numbers of those. So sometimes they may be on order. And if you have any issues with this system at all, let me know. Some of y'all have had some issue with what they call low noise, where the microphones are lower recording levels, and there's some problems with that. There is a like something you can go within the system and fix that, and we do have that for like a troubleshooting guide. So if you ever see that pop up, it's definitely something that needs to be looked at, or I can send you the directions to it and let you, put that on your computer to fix that. Because same thing, if it's saying low noise, then it's a good chance that audio is gonna be affected. So you just don't want that. I mean, if we're getting a warning of some kind, we just want to know about it ahead of time. Go ahead and get everything fixed right away. Any issues with that right away. And if you seem to be having any microphone issues, things like that, let me know and we'll get something filed. Some are handled through the county and some are handled through state, through BIS. So if you know you have a county person who handles like your tech issues, sound system, that type thing, talk to them about it and see how they can help you. Or it could be it's just not getting fed into the BIS system. It could be that. But if it's county microphones, county PA system, ask your county people first. If they say everything's good, then we'll call BIS and talk to them or send something through their support email and get them to do it. If we to look at it, if we need to get new microphones, we will. If we need to get whoever the sound vendor and BIS together to work out an issue, we'll do that as well. Because having those systems in there, we need good quality recordings in case it comes back, even for years to come, where somebody needs to go in and do them. And create the record and everything. So it's definitely something that we need to make sure is uh, working like it should be. And I think as I was mentioning that, if you do want more, uh, hoping to have more court time or something like that too, let me know. If you want to start doing some extra transcripts if somebody asks, let me know. I've got some people who have already been volunteering for that are experienced court reporters. So same thing, if you ask and you need help and you are afraid to ask, just know that it will be someone that's got experience in doing that. It won't be given outside of the AOC. It'll be given to a court reporter within the state that uh, does transcription. So that's no worry about anything to do with that. And then the shadow, in case you're seeing this on here, would be someone coming in. It might even be, somebody who's thinking, hey, I think I'd like to be a court reporter, but I want to see what it's like first. So it could even be a shadow for something like that as well. But I think that's everything I could possibly think of at this moment. And thank you all for attending and listening. And let me know if you think there's anything that I forgot you think is real important. We need to get out to new reporters and anybody interested. And maybe somebody just thinking they may be interested in court reporting itself. It's a lot of information. But sometimes there's a lot of information when you first start something. So getting a foundation and just hearing information as you start learning it and putting it to use, I think it just makes it a whole lot easier. So, again, I appreciate what you all do. And thank you for working with us and work, the, work through the criminal courts and for the sacrifices I know you've made from time to time doing transcripts and things like that, and for being in court and the things you've had to listen to. I don't take that for granted at all. I know it's not easy, but anyway, um, I sure appreciate you all. And if there's ever anything I can do, just please let me know. Thank you. And y'all have a good day.